All right, we'll go ahead and get started now that it's 4 o'clock. My name is Elizabeth Bolduc, and I am an attorney with Bugbee and Conkle. I focus primarily in labor and employment, discrimination, and all aspects that come up in employment aspects for employers. Today, we are going to talk about a new bill that just President Trump signed earlier this week, or technically it was last week, that provides for the first time on a federal level certain benefits and paid benefits to employees. So this webinar will primarily focus on that legislation. There is current legislation before Congress right now. However, nothing else has passed. When something does pass, I am sure you'll tune back in for a webinar or some sort of publication that we will update you all on. So we can go ahead and get started. So on March 18th, 2020, President Trump did sign the Families First Coronavirus Response Act into law. So I will kind of make a few caveats here that this was an act that we saw Congress create in a very short period of time. So it originally was in the House earlier in the week. It passed the House. In the late hours of the night, the House of Representatives repealed that law and made some changes to it. And it was put to the Senate at that point. The Senate on the 18th did approve the repealed and revised, or the revised version of the bill. And then President Trump did sign that on the same day. So as far as legislative history goes, there isn't a bunch of meetings on this in the sense of years of negotiating and thinking how this language will play out. This was a reactive bill to respond to what our nation is facing right now, to just kind of provide everyone some sort of context of why this bill was enacted. And so it is currently not the law. It's not into effect. We're getting that question a lot from employers thinking that they have to get in compliance as of March 18th. There was a provision in this bill that said it is to go in effect no later than 15 days, which would put it on April 2nd, 2020. We have not heard any other regulations that would start this bill or enact this bill any sooner than April 2nd, 2020. So that is our target date. And then as far as how long this bill lasts, it will sunset on December 31st, 2020. So it will expire. It is a shorter term bill in law. Okay, so the Families First Corona Response Act is actually a large bill, and it addresses a few things. It addresses, free coronavirus testing. It also establishes various paid leave benefits. It enhances the unemployment insurance tax dollars and what states are required to do to get extra money. It expands some other Medicaid funding and initiatives in there. But for purposes of today's webinar, we are going to draw two acts which make up the FFCRA. And that is the Emergency Family and Medical Leave Expansion Act, and then the Emergency Paid Sick Leave Act. So there are two separate acts that fall under this law. We're going to first talk about the Emergency Family and Medical Leave Expansion Act. A lot of the principles that we discussed in this act will apply when we talk about the Emergency Paid Sick Leave Act, but we'll hash that all out when we get there. All right, so the first, what is it? And it is a temporary amendment to the FMLA regulation. So as most of you are aware, there is already some sort of FMLA, Family and Medical Leave Act, out there that employers have to comply with. And so this is a temporary amendment because it only lasts until December 31st of 2020. and it provides more benefits and different benefits than what the current FMLA Act does right now. And so for those who are FMLA junkies and know about it, the traditional FMLA provides that covered employers who employ at least 50 employees within a 75-mile radius are required to give employees who have been employed with the company for at least 1 year and work the 1,250 hour threshold up to 12 weeks of unpaid leave for various reasons. Now, this Emergency Family Medical Leave Expansion Act builds on what is the current regulation and provides that now employers have to provide certain paid benefits for qualifying reasons. And we'll go through all the threshold issues. We'll go through what the qualifying reason is and how this is all going to work out. All right, so covered employers. So here, this is a lot different than the traditional FMLA or the original FMLA regulation. So now this new act applies to all employers with fewer than 500 employees. So we're really talking about small to mid-sized businesses. It's excluding those larger businesses of over 500 employees. It also applies to government agencies. So that would be schools, local, federal, and state governments, and political subdivisions. That would be all inclusive. There is a portion in this bill that says small businesses with fewer than 50 employees may be exempt from the leave if such leave would jeopardize the viability of the business. And so based on the plain language of the statute, it doesn't seem that just because you are an employer with less than 50 employees, you are automatically exempt under these new benefits. And so hopefully the Secretary of Labor will be issuing some sort of guidance in the upcoming days to let us know who are the small businesses that are exempt or can be exempt. What is the requirements to show that giving such benefits would actually jeopardize the businesses? The statute gives authority to the Secretary of Labor to come up with those sort of emergency regulations, and we're hopeful that we will get that soon. But for right now, it's kind of a gray area. And same with figuring out, who exactly is the 500. How do you count the 500 employees? Is that at a single facility? Is it total? Again, the statute was created rather fast. That's not all weighed out. It seems that you would use the test under the FLSA or the FMLA to figure out whether or not you are considered a single enterprise or integrated employer and meet that threshold. But again, we're hoping that the Secretary of Labor will be coming out with that guidance shortly. All right, so now that we've discussed who are the type of employers that are covered by this act, let's talk about the eligible employees. So again, this is a big, detour from the original FMLA regulations. So it applies to full-time and part-time employees who have been employed, so meaning on the payroll, for at least 30 calendar days. So this is, a lot different than the test under the original FMLA, where you have to be with the employer for 1 year and work a specified amount of hours. But this is, a lot different. It doesn't say how many hours you have to work, anything like that, just 30 days. Once you've been with the employer for 30 days, you come under a qualified reason, you can take these additional benefits. And so the circumstances for this additional FMLA is where an employee is either unable to work or telework due to the need to care for minor child. So under the age of 18, because a child's school or place of child care has closed due to a public health emergency. So let's break down some of the legalese or the phrases that are in that language. And the first is a public health emergency. So what that means is an emergency with respect to the COVID-19 declared by federal, state, or local authority, which, President Trump has already declared that it's been an emergency for those employers who are here in Ohio. Likewise, Mike DeWine has declared this a state of emergency. And then for child care provider is defined as a provider who receives compensation for providing child care services on a regular basis. So that's a pretty broad definition, that I think includes, facilities, child care facilities, along with obviously babysitters as well that are on a regular basis. And then third, schools is defined as an elementary school or secondary school defined by the Elementary and Secondary Education Act. So again, it's a very broad, encompassing definition. So I would think of a traditional school when you're wondering if an employee is eligible for these benefits. Okay, for notice period, under traditional FMLA law regulations, employers were to give foreseeable notice when they can. And so in these circumstances, not all reasons for leave are going to be foreseeable. And so under the Expansion Act, employees must only provide employers with such notice of leave as practicable. So if, your employees get an email from their child care provider that lets them know that their daycare is closing in a week, they should be providing you notice on that date. But maybe it is a circumstance where they just find out the day they pick up their child that, starting tomorrow that they're not going to have child care. So I do encourage employers to be flexible in that sense. And that's kind of how the regulations are being interpreted. So now that we've talked about, who does this cover, what types of employees are eligible for these benefits, and how do employees become eligible for these benefits, let's talk about what the actual benefits are. So there are paid leave during it, but for the first 10 days of the expanded FMLA leave, so in other words, leave to take care of a child whose either child care facility or school has been closed due to the coronavirus, the first 10 days or the first 2 weeks of that leave may be unpaid by the employer. So during that period, it might be unpaid. We might muddy the waters when we get to the second act, which might run, and blend with these type of benefits. But for purposes of only the Emergency Family and Medical Leave Expansion Act, the first 10 days may be unpaid. After that 10-day period, employers do have to pay their employees 2/3 of their usual rate of pay. And so you would find that number by how much do they typically make. If they're an hourly employee that is scheduled 20 hours a week, well, then they're paid 2/3 based on their regular rate of pay, if it's $10, $15, $20, and then for that 20-hour period or how much they work. There is a cap, however, on benefits at $200 per day and then $10,000 in total. And then, there's something important here. Employees may elect to substitute any accrued and personal days during such time, but employers may not require the employee to use the paid leave benefits. And so I think this is what's coming up the most right now is for those employees who have, or employers who have employees that need to be off of work right now because the school is closed, or the daycare is closed due to the coronavirus. At this point, you can tell your employees that they may elect to use their accrued vacation time or personal time because the law is not currently in effect, and it won't be until April 2nd. So during the time that the law is not in effect, I think it's a great opportunity to tell your employees, well, you can take use your accrued vacation time, personal time, before these benefits actually kick in. Just like under the traditional FMLA regulation, once an employer's need for that leave, so either the child care facility has opened up, or they're able to telework, or their 12 weeks has been exhausted, you do have to restore them to the same or equivalent position upon the return to work. There is, however, an exception for employers with under 25 employees. And it is only when the employee's position no longer exists after the leave due to either economic downturn or other operational changes that were affected because of the coronavirus or during that leave period. If the employer is unable to determine when they're going to have that open position, or if they can put them back in that position, they do have an obligation to make all reasonable efforts to contact the employee if that equivalent position becomes available within 1 year of either their end of need for leave or their exhaustion of that leave. So there is a recontact period for those employers with under 25 employees. As I mentioned earlier, consistent with what I mentioned earlier, and the regulations, it's made it seem that the Secretary of Labor can come out and say that certain employers who have less than 50 employees are immune from the threshold of this new law. Likewise, the regulation says employers with less than 50 employees are immune from civil FMLA damages, which just means that they're protected from an individual suit basis. However, it appears that the Department of Labor can still bring a suit on behalf of individuals. It just appears that small businesses are going to be protected from personal and civil suits. There is also an exclusion for healthcare providers and emergency responders under the FMLA Expansion Act. And to the extent the new statute doesn't define what exactly a healthcare provider or emergency responder is, rather it refers back to the old FMLA regulations, which is defined as a doctor of medicine who is authorized to practice medicine or surgery by the state, or any other person determined by the secretary to be capable of providing healthcare services. So in regard to this definition, it kind of is used for a different reasoning under the traditional or the original FMLA regulations. So for right now, we would suggest that it be on a case-by-case basis of whether an individual is providing a healthcare service or function. So, not everyone who works in the healthcare industry is going to be deemed a healthcare provider. Rather, I think it's going to come down to actual job function. So nurses, doctors, nurse aides, individuals who are actually providing some sort of healthcare function. While there are other employees who are essential to the support of a healthcare practice. I don't know, based on this regulation, whether or not that would apply to them, like billers, secretaries, employees of that nature. We're hopeful that, again, that the Secretary of Labor will come out with some guidance on this before April 2nd. All right, now switching gears to the Emergency Paid Sick Leave Act. So I mentioned at the very beginning that there are really two acts that we were going to dive deep in today. The first one was the expanded FMLA Act, and then the second was the Emergency Paid Sick Leave Act. So this one has very similar principles to the other one, and we can use some of the interpretation that we used in the FMLA Expansion Act to determine what employers' obligation is going to be here. So again, it requires employers with fewer than 500 employees, and it also, again, applies to government employers. So those federal, state, and public employees, school employees, are also eligible under the Emergency Paid Sick Leave Act. And this act is a little bit different, as it pays 2 weeks paid of sick leave and at an employee's regular rate. So the first three reasons that an employee can be qualified for sick leave is really discussing about an employee's own situation. And then the categories outlined in red, the last three, are really the caregiving functions. So those functions that the employee is caring for another. So the first one is an employee is subject to a federal, state, or local quarantine or isolation order related to the COVID-19. So a lot of the questions we're getting right now is, well, what if our state enacts a stay-at-home order or a shelter-in-place order? That is something we're seeing right now. The law doesn't specifically address that as of right now, whether these stay-at-home orders or these shelter-in-place orders are actually quarantine orders. So hopefully, again, the Secretary of Labor will come out with that. It is our interpretation, though they're not, though. These aren't a federal quarantine, a state quarantine, or a local quarantine. Rather, it's just restricting the type of businesses and functions that individuals can do. Again, the second qualifying reason is when the employee has been advised by a healthcare provider to self-quarantine because COVID-19. And as everyone knows right now, it's really hard to get tested in a diagnosis. I know in the state of Ohio at some point, there was limited testing capabilities and tests out there. So I think employers are going to have to be a little bit flexible in the sense of, what kind of notice do you require for, experiencing symptoms or being advised by a healthcare provider? Maybe it'll be just simply an email from a healthcare provider, a chat box from a healthcare provider saying that you should be quarantined. Likewise, when an employee is experiencing symptoms of the COVID-19 and seeking medical diagnostics, again, hospitals and medical providers are, I think, inundated right now with responding not only to their normal practice, but also the issues related to COVID-19. And so I think, again, it's going to have to be a little bit flexible in the sense of how do you require your employees to provide documentation to show that they meet this threshold. And then the last three is really about the caregiving function. So when an employee is caring for an individual subject or advised to quarantine or isolate. So it's interesting here that the legislation says individual and not family member. Under the FMLA regulations, the traditional FMLA regulations, it's always been known as family members caring for family members. So it does appear that the legislation is a lot broader when it comes to the Emergency Paid Sick Leave Act. And then the fifth threshold or the qualifying reason would be when the employee is caring for a son or daughter whose school or place of care is closed or child care provider is unavailable to the COVID-19. And so I mentioned it earlier in my presentation, but this is when the Emergency Paid Sick Leave Act will overlap with the expanded FMLA Leave Act. And so there's going to be times where the two acts are going to overlap each other and work in correlation with each other. And then finally, the employee is experiencing substantially similar conditions. This is kind of the catch-all that I think they put in the law just to provide, help for employees who might come up with conditions that are deemed later to, be related to COVID-19. All right. So this sick pay is different, obviously, than under the FMLA Expanded Act. Under this regulation, full-time employees are entitled to 2 weeks, so 80 hours of usual pay, so their regular rate of pay. And what is unique here is, unlike the FMLA, where an employee has to be working for 30 days, an employee who's been on the payroll or who's been working for the employer for 1 day is eligible to take these benefits. And then part-time employees are entitled to a prorated number based on the number of hours they work in the 2-week period. And so if you had an employee that, again, works 20 hours a week and they're paid $10 an hour, that's how you would calculate it based on that rate. So $10 an hour and on 20 hours a week. So there are limits and caps, again, just like there were under the FMLA Extension Act. So when an employee is taking leave for themselves, so the first three rationales on that list, I think they were outlined in blue. So the first three, they are paid at their full rate of pay, and there is a limit of $511 per day and $5,110 in total. So that's when the leave is on a personal basis. Now, when employees are taking leave to take care of a family member or other individual due to a self-quarantine or the school closure, they're paid at a 2/3 rate of their regular pay. And that is limited to $200 per day and $2,000 in total. So again, employers may not require that employees use other pay leave provided by the employer before they use this Emergency Paid Sick Leave Act. So you can't tell employees, that they first must exhaust their accrued PTO before they can get these benefits. And consistent with this bill or this law sunsetting in December of 2020, these benefits do not get to get carried over from one year to the next. Now, talking about exemptions, an employer may exclude employees who are healthcare providers or emergency responders from this coverage. Again, under the Emergency Paid Sick Leave Act, Congress did not define specifically who healthcare providers are. We're hoping that the Secretary of Labor will come out and give us guidance on who those healthcare providers are and emergency responders, so we can use the same sort of interpretation that we use in the FMLA Expansion Act to come up with a case-by-case basis. Again, small businesses with fewer than 50 employees may be exempt from these requirements so long as they jeopardize the business as a growing concern. So if you could demonstrate that leave would really jeopardize the business, you may be exempt from this. Again, that's something we're waiting on the Secretary of Labor to come out and give us guidance on. I do not think it is as of a right, but we shall see. All right, so under the Emergency Paid Sick Leave Act, there is a separate retaliation prong which says that if an employer retaliates or take any adverse employment action against employees who take leave under the new law, they'll be subjected to additional penalties. And you could bring a retaliation lawsuit under the Emergency Paid Sick Leave Act if your rights were interfered with or if you were retaliated against. The bill also makes clear that if employers fail to provide these benefits, that it will be treated as a minimum wage violation under the FLSA, which, can result in fines, back wages, double wages, and liquidated damages. So I think a question that most employers are asking right now is, well, how are we going to pay for this? I mean, this is the first time in America's history that we've had a federal mandated paid sick leave or family leave act. And so how are employers who didn't have the resources saved up to afford for such benefits going to be able to upfront the cost? Well, they've come out to say that employers will receive a refundable tax credit for at 100% for qualified leave under each act. And so that's why it's really important to make sure that the employee is in fact qualified for these leaves, because if you're paying out the benefits, you surely want to receive the refundable tax credit. And again, this is just about, it's consistent and the same for if you are a self-employed individual. All right, so I believe it was Friday evening that the Treasurer, IRS, and Labor came out with a little bit of guidance. And they have said that, employers will receive 100% reimbursement for paid leave and benefits pursuant to the Act. So this includes health insurance costs. I know we were getting a lot of questions about that, but it does include that. Employers are going to face no payroll tax liability. And the IRS has come out to explain how this is going to work. So when employers pay their employees, typically they are required to hold certain types of taxes from employees' paycheck. That now employers can use that fund to support this program, essentially. So how does that work? Let's go to an example. So if an eligible employer paid $5,000 in sick leave and is otherwise required to deposit $8,000 into payroll taxes, including taxes withheld from all its employees, the employer could use up to $5,000 of that $8,000 of taxes it was going to use to deposit for making qualified leave payments. The employer would only be required under the law to deposit the remaining $3,000 on the next regular deposit date. So again, another example, if an eligible employer paid $10,000 into sick leave and was required to deposit $8,000 in taxes, the employer could use the entire $8,000 of taxes in order to make qualified leave payments and file a request for an accelerated credit for the remaining $2,000. So that's an instance when the payroll tax would not cover the leave paid. and equivalent child care leave and sick leave credit amounts are available to self-employed individuals under similar circumstances. These credits will be claimed on their income tax return, and they will reduce estimated tax payments. So under both of these acts, guidance has come out so far and said that the labor will be issuing a temporary non-enforcement policy that provides a period of time for employers to come up with compliance of the act. So that doesn't mean, though, that employers are just out there twiddling their thumbs and not trying to comply with the act. So you would have to show a good faith, reason of trying to get in compliance and getting in good faith with the new act. And they're going to be giving kind of a grace period during this time. The next 30 days, they really are just going to try to work. The Department of Labor is going to try to work with employers on figuring out their legal obligations and how to work through all of the hiccups of this law, and not be focusing on prosecuting cases under the new law. So we've gone through both the acts. I'm going to take questions momentarily. Carrie, do we have any questions?
Okay. So will the EFMLEA, an emergency paid sick leave, be retroactive if the individual was negatively affected prior to April 2nd?
No. So you're kind of, so that's why I said, during the time that this is not effective, you're going to want to encourage your employees to take their own personal leave or enforce right now. If you have that, employees have to take their, a portion of their accrued pay time while they are off work. If you have policies like that, you'll want to enforce it before this law is enacted. You are not so far. The Secretary of Labor could come out tonight during this presentation tomorrow. We're not sure, and let us know that it is retroactive, but based on the plain language of the act itself, there is nothing in it that says it's retroactive. So for employers who are paying benefits right now, come April 2nd, all of these benefits are going to renew, and you're going to be required to comply with the law on that date.
Okay, the next question is, and this I believe is in regards to the 10 days that are unpaid. Are those consecutive days, meaning weekends too, or days worked?
So that is an interesting point. So right now it appears that under the traditional FMLA, many employers know that you can have intermittent leave. I think the same is true here. That is something that is not 100% discussed. Actually, it's not discussed at all in the new law. We're hoping the Secretary of Labor will come out on this issue as well. They did have a town hall hearing a bunch of businesses' concerns and issues of how to execute this new law. I believe that would, that's one of the things that was raised there. But yeah, reduced schedules and intermittent leave are certainly in play here, I believe.
Okay. The next couple of questions deal with the usual pay. So the first one, if hourly and often works at least 40 hours plus overtime, can we base the 2/3 on the 40 hours regular pay?
So can you read that again? I'm sorry.
Yep. If an employee is hourly and often works at least 40 hours plus overtime, can we base the 2/3 on the 40 hours regular pay and not the
when
overtime?
They have no, you would want to do it with, and if they typically work overtime, you would want to include that. So for employees who have varying schedules from week to week, or to the extent that they, they pick up overtime in one week, they don't pick up overtime in another week, and the employer is unable to determine with, exact number of hours the employee would have worked if they wouldn't have taken that leave, they should provide a number equal to the average number of hours that the employee was scheduled per day over the 6 month period. ending on the date in which the employee takes such leave. So you would want to kind of look at, the last 6 months, what is the average?
Okay, that answers the next question too, which was how far back do we use to calculate usual pay? Okay, the next question, does this apply if the employee is currently laid off due to COVID-19?
That's a great question. And my understanding of this, both acts, is that they are qualified because of a reason. And so under the FMLA extension, it's because an employee is unable to work or telework due to the needs of their minor child. Under the Emergency Paid Sick Leave Act, there is also 6 qualifying reasons. And neither of the legislation or the act doesn't say because of a temporary layoff, a furlough, or anything to that extent. So if in fact an employee is off because of a temporary layoff or a termination during this period, they would not, based on my understanding, not be eligible for these benefits. We're definitely talking about companies and people who, as of right now, are laid off. Benefits, the law is not even acted at this point. So if that is the reason, because of a layoff or because of a furlough due to the coronavirus, is not explicit into the statute. Now, the Secretary of Labor could come out and provide guidance otherwise, but until then, that is our interpretation.
And then a related question, do we retract the layoffs and pay people under the new legislation?
I'm not sure I completely understand the question. So if I'm understanding correctly, if they were to call back employees, if an employee fell under one of the qualifying reasons for either the FMLA Expanded Act or the Emergency Paid Sick Leave Act, at that point, they would be eligible for such benefits. But you don't have to retract your employees from layoffs because of this new act. I do want to just spend a minute on, I know I said I would keep the legislative update to this new act, but I do want to quickly mention that there are quite a few Ohio executive orders. So for those employers who do operate here in Ohio, the latest one was on 3/22nd or the 22nd. And, when you are looking at benefits from a federal level, you also have to be cautious that there are things on a state level that might provide additional benefits and local level that might provide even more additional benefits. And Mike DeWine's executive order yesterday, he does, or I guess it's on the 22nd, Sunday, he does say that, businesses should ensure that their sick leave policies are up to date, flexible, and non-punitive. So taking into mind that during this period, Mike DeWine has said for Ohio employers that their sick leave should not be punitive and they should be flexible. And I will leave you with that thought. If I did not answer any of your questions that you have, please shoot me an email. Or call me. I would be happy to discuss anything that might come up or any questions that we didn't get to. For those of you who asked a question, we will follow up with you. But thank you, everyone, for tuning in.